But the initiation of the transaction also depends at times onto the relationship. So how will you determine that this is a related party transaction, arm's length transaction or not? No guidance there, but the requirement has come in that you have to do an arm's length transaction. Dividend cannot be given, only if you have listed company shares, they can be given. So the proposal from the institute will be, it's not yet gone, again it was the second draft, that the restriction be removed, or at least it should be added that all companies' shares can be given. It should not be restricted only to the shares of listed companies. Now, interesting bit here also. The present jurisdiction for the schemes of arrangement, section 284 to 287 presently, rests with the court. And there has been an established principle that this jurisdiction of court is a separate jurisdiction. For example, in the scheme, you also issue new shares to people, but you do it without further issue. So the jurisdiction is separate. The rights issue does not get applicable here. You also cancel shares, but you don't have to go through specially against the provisions of 96 reduction of share capital. Why? It's a separate jurisdiction. Then it's the jurisdiction of the court. The SACP is proposing that just this jurisdiction be transferred to the commission. So if it gets enacted, all the mergers, demergers, carve out and everything will actually have to be approved by the commission. Their point of view is that the court's delay matters. We don't want things to get delayed, hence we want to do that. And secondly, we are also the regulator of NBFC's mergers, NBFC's schemes. So rather than correcting that, this power is proposed that this will also go to them. The institute's comments were that since it's a separate jurisdiction, and a lot of other matters also come up. There is transfer of asset without any act. So a court has jurisdiction on the transfer of asset, but SACP does not necessarily have that jurisdiction. There would be issues coming up from the minority shareholders at times. Court has a jurisdiction to settle those issues, to record evidence, to give directions that the SACP does not otherwise has. But it is proposed that this will go to the SACP. It was there in the first draft, the institute commented, the institute debated with them for this to remain there with the courts, but in the second draft also this is exactly the same provision that this power will go to them. In UK, the power still is with the court, rightly so. In India, the power is with the tribunal, which is still a judicial body, which is not directly a body who is a regulator. So the regulator approving something in itself is a conflict of interest, but this power is, even the second draft, is retained there to go to them. These have been borrowed from the Indian and the British jurisdiction. One, that wholly owned subsidiaries of a parent can be amalgamated without any court, without SACP. So if there are 2 or 3 subsidiaries which are wholly owned, their board can pass a resolution and the entities will stand amalgamated. Similarly, a subsidiary can be amalgamated into its parent if it is a wholly owned subsidiary. So this is an enabling law where they are saying that without the intervention of the court or even the SACP, the mergers can go through if it is within the same group, which is 100% wholly owned companies. The institute welcomed that and also gave proposal that on the same lines there should also be converse to it. Meaning if a company is to hive down an entity, some of its business down to a 100% wholly owned subsidiary, that should also be allowed on the same principle without any approval of the SACP or the court. Similarly, if there is a demerger where the proportionate shareholding is not changing, so by default that should also be allowed on the same principle that nothing is changing. So a board resolution or even the EGM resolution should be enough for that. But these two have not been added into the second draft, and only it is the wholly owned subsidiaries where the mergers, this ease has been given to them. Now, this is an interesting regime that SACP wants to bring in. It was not in the first draft. In the second draft, they have brought that up. They want to have the regime of registered valuers, meaning wherever there is a statutory valuation required, No one can do that other than someone who's licensed by SCCP to do it. And very recently, they had also issued the draft regulations for this. I don't know if you have gone through that. Many of you definitely would have gone through that, which required that this license will only be given to incorporated companies. So valuation wherever required under the law, even that is the valuation of securities, valuation of intangibles, valuation of goodwill, which is customarily done by the chartered accountants. They will not be able to do that because they cannot get themselves incorporated unless they make a separately incorporated entity and there is a registration for that. Second, in the regulations they have proposed that they want to have a separate QAB. Just like for the audit you have a QAB with the institute, they want to have a separate QAB under them that is going to do the quality assurance of the valuers. The proposal from the ICAP will be that you make it in line with the QAB which is being done by the ICAP as far as a body of professionals is concerned. This is applicable to all valuators, even the tangible asset valuators. So if some valuator does not have their relevant institute, let there be a regulation directly by the SCCP. But if certain practitioners like chartered accountants have their established institute, so the matter as to their conduct, their QAB and everything should be dealt with at the level of the institute. But it's a recent amendment that has come in the second draft, so this has not yet been thoroughly debated, but will be debated by the ICAP with the SCCP now. Interestingly, in the same one, there is a statutory provision coming up for the penalties to the valuer for damages to the company or any other person who gets affected. So that restriction of liability clause in the engagement letters, maybe that will also get affected even in case of these services, because statutorily you are giving an authority to other parties to put a penalty onto the valuator. No company will now be able to accept deposits from the general public except the banking companies or the companies which are given approval by the SCCP. And if there is a contravention and some company accepts deposit, the minimum penalty is equal to the amount of deposit. So if it's $1 million that they have taken as deposit, it's $1 million which is the minimum penalty to be imposed on that, beyond that $1 million to be returned, of course. And if someone has solicited deposit but not accepted deposit, that's the normalized penalty available. But for accepting deposit, there is also imprisonment now. This is another suo motu power, new suo motu power of commission. They have come up with a serious fraud investigation. What is a serious fraud? Which is a serious fraud? It's literally defined as a serious fraud is the one which is in the eyes of the commission a serious fraud. So they can appoint professionals to investigate these frauds. No clarity how this will be triggered. So the power right now, if this gets enacted will rest with the SCCP as suo motu power. When can they do that? There is no regulation. Interestingly, there is no power to the SCCP to make regulations. Had it been that there is a power that they will make some regulations with the public opinion and so on, but even that is not there. So it's a new concept that they are coming up with, serious fraud investigation. Just like directors' penalties, that what they should not do, there are new grounds which have been added in which a company can be asked to be wound up by the court. And those grounds are, if a company does not file its financial statements for 2 years, if a company does not file its annual return for 2 years. So this is a ground on which the petition can be made by the registrar to the court that the company be wound up, regardless of the quantum or the net worth or the number of transactions. It's just 2 financial statements not filed or the 2 annual returns not filed. Company acting against the interest of Pakistan, conduct by business conduct of business by a company in the manner oppressive to minority, revocation of license, but my favorite is the last one. Commission is empowered to add any other grounds. So without any other statutory intervention, the Commission will have the power to keep on adding, I don't like this, and so on, and that will be a ground at which at least they can take the matter to the court for that. Is it namaz? Okay. So I think we should be able to cover this first one. There was another requirement of disposal of undertaking which has remained unclear, and many views had been there whether you are disposing of an undertaking or not, and there was no guidance in that. The power of disposal of assets was with the board unless it was an undertaking or a sizable part where they had to go to the general meeting for that. So now some explanation to that has been added, that an undertaking is where the investment exceeds 20% of the company's net worth, or where the revenue from that undertaking exceeds 20% of the company's revenue. And these all based on just the last year. Sizable part is where the 25% or more of the value of an asset is in that class. So it's good explanatory one, that at least some clarity has come in as to what will be an undertaking or a sizable part thereof. This is another edition of the second draft. A company cannot call itself that I am Sharia compliant. Similarly, no product that the company introduces can be called that this product is Sharia compliant. The SECP will give a certificate, not a fatwa, that this is Sharia compliant or this is not Sharia compliant. There is no regulations yet. What will be the regulations? The SECP will have power to make the regulations for that, but this Sharia compliant stamp will be coming from the Commission. In the question and answer, I would love to have some proposals onto this one, that how to go about this, that who should give this. Then the concept of the Dormant Company has recently been added, the same concept that is there in the Indian law, that there is a concept of a dormant company which does not have a lot of transactions. There will be minimum compliance requirements there, and usually these assets, these companies will be held to hold intangible assets or to hold shares in the other companies and so on. There's another requirement in the Indian law similar to this one, which is not yet replicated in this draft. Yet replicated, I am saying third draft is still open, which is that in India you cannot have a group that has more than 2 tiers of resident companies. So a company, a holding company, and another holding company, that's it. You cannot have 3 companies in a chain which all 3 companies are resident companies, and then there is a 4th company there. It's not yet there in this draft, but the SECP has been discussing about this. Why I'm just talking about that? Because this dormant company concept has also been brought up into the second draft. So it's a recent thought. So maybe in the discussions that may also come up. These were the other, some of the things that ICAP had proposed, but on which nothing has come up in the second draft also. So one proposal was that similar to India, at least there should be enabling provisions in the law. No one knows when this law will again change. So at least there should be enabling provisions in the law that migration of the companies can be done, meaning Pakistani companies can get amalgamated with non-Pakistani companies and vice versa. In one way it is there, like a branch of a foreign company operating in Pakistan can be amalgamated with a company in Pakistan. But with the foreign companies, this is not yet there. So at least the enabling law should come in. Maybe it is put in that this will be applicable from a date of notification when the SBP is also online with that, but at least the enabling law should be there, but that has not yet come up even in the second draft. Second thing that ICAP had proposed, this is also an interesting one. Right now the election of directors has a specific way of election and the specific way of calculating the number of votes. And interestingly, the number of votes disregards the voting rights but only talks about voting securities. Until there were no different classes of shares, this was fine. But suppose now if I have class A and class B shares, class B has 10 times voting rights compared to class A. Both securities are voting securities, so the number of shares that they will have will be exactly the same. Because the number of shares for the number of votes for the directors election is not based on the number of voting rights. It is based presently on the number of voting securities that you have. The ICAP had proposed that this mechanism companies should be allowed to have in their articles. At least for the private companies, how the directors will be elected, there should be a mechanism available for them to put into their articles. And if there is none, then of course you can keep on having whatever criteria that they have now, but it has not yet come even in the second draft. Another proposal was again to have the enabling law to have corporate directors, just like in other jurisdictions. Maybe not right now, in some time, to have corporate directors sitting onto the boards of the companies. Maybe the SCCP could come up with licensing regimes for that later on. This may not be applicable from tomorrow. A power should be there in the hands of SCCP to notify that, but it was time when the law is revamping, so this could have been added into the law, but it has not yet been added even into the second draft. Okay, we'll continue after namaz break. So, 15 minutes? 15 minutes? Okay. Move on. And the last of the corporate matters proposal that was the concept of segmented companies, which is there in a lot of jurisdictions, that where multiple businesses are being done by the same company and the risk profile of one business is not to be shared with the other one. So there is a concept where one company can have, one legal entity can have different segments with all separate legal rights bifurcated within those segments. So another proposal of the institute was that again enabling law of such companies may also be considered at this point in time when the law is being changed, so that it's there and whenever is the right time for it to start up, this can be utilized. So these were the corporate matter changes there. Moving on to the second subject, that was preparation of financial statements as to what is changing there, and most of the changes, by the way, were revolving around the corporate matters. There are very few changes as far as the preparation of financial statements and audits are concerned. One, the companies have been segmented into different classes now, being micro companies, small sized, medium sized, and public interest and large sized companies. So previously certain classes were also there for the purposes of their financial statements preparation, but that classification was in the schedules. This classification now is into the main body of the law, and even the thresholds of the net assets, thresholds of the paid up capital and the revenue, all those thresholds are also proposed to be embodied within the main law. So the proposal from the ICAP was that at least these thresholds should be open to change by the commission instead of having promulgated into the law, so that when they become outdated and suppose a next change comes after 10-15 years into the law,